Welcome, everybody. We're going to start the April 10th Equalization Board meeting. So we'll call it to order. Do we have to take a roll call or anything, Shannon?
I don't know.
No?
It's your meeting. When you
Okay.
tell me you're ready for me, I'll start
We're-
talking.
I think we're ready. We don't have to approve any agenda or anything, so I think we just start.
Yeah, you don't have an agenda. The agenda is dealing with the exempt properties. So just an overview of what happens is any property that claims an exemption for property taxes has to make an application to my office by November 1st of every year. Every property, churches, charities, everything. And they do that. We are required to look at those properties and to determine if it meets the statutory requirements for an exemption and make a recommendation to the board. All properties that claim an exemption from property taxes are published in the newspaper so the public knows. And then it comes to this board, and the board then approves or denies all exemptions. I have a recommendation for you, but it's the board that makes this decision. The property owners, if they're unhappy with what the board does today, can come back days later, and we've scheduled that for the 20th. So if they want to make an argument, if they're unhappy with what you do here, they can come back. We've got one or two people that I think want to say something here today, though, as well. It's a public meeting. Anybody can come to this meeting. Nobody does because it's just not very interesting. So we will go down through the exempt properties. If you have a question about something, I'll do my best to answer it. I don't have a lot of notes here, but I can try and answer it. And we have split all of these exempt properties into several different lists. All of those that were exempt in the past and recommend exempt again, those are on one list. All the properties that are a partial exemption on another, all of those I recommend deny, those are on a separate list. So we'll deal with them separately so you can see what different kinds of properties are becoming exempt. The partial exemption, an explanation of that. The state law, several laws that deal with exemptions, all say that the property has to be owned by an exempt entity and used for an exempt purpose. And an exempt entity is defined in state statute, a religious organization, a school, a benevolent organization, all of those. It has to be owned by that entity and used for an exempt purpose. The property has to be used for that exempt purpose. There are a lot of properties that are used for an exempt purpose and then used for a non-exempt use. And so they become partially exempt, 50-50, something like that. Okay, so we'll start through it, but the first thing, do add some omitted property? Okay. You have a notice of intention to raise valuation on historic Rapid City. This is it's not an exempt issue. Historic Rapid City is not an exempt entity, but it's something we do on this day because property owner can come back later, so they can come in on the 20th. But we've already talked to them. They're well aware of this. We have a property that used to be owned by the State Department of Transportation, so it was exempt from taxes, and we missed it. We're asking this board now to put this property on the tax roll at $3,100. And the property owner, Historic Rapid City, will be notified of that. And if they wanted to argue that, they can come back on the 20th to argue. But they're not. We've already talked to them. They're well aware of this. This is just the official process. It was missed in the assessment. We want you to add it.
So you're looking for a motion to add the assessment on to the historic Rapid City
For $3,100.
for $3,100.
I would make that motion.
Moved by Buskerud,
We don't need a signature.
seconded by LaCroix. Any discussion? Seeing none, all in favor indicate by saying aye.
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 Aye. Motion carries.
We do that when we find these during Board of Equalization, but we also do it in the middle of the year. We will have property, if the state DOT sold a property in July to a private person, it becomes taxable in July. So we will add it to the tax roll for part of the year. That happens several times a year. The auditor does it, and she notifies the property owner, we've added your property to the tax roll for this much, and the property owner can come in and argue if he wants. It's just convenient to do it while the Board of Equalization meets, since we know about that. So, let's go to the exempt properties. Try the full exempt list. That's the biggest list. At the top, it says full exempts 2018. This is all of the properties that are 100% exempt that I recommend you approve the exemption on, but I want to pull one of them off. So I would like you to act on this list to approve the exemption on all of those on that full exempt list, except for Lakota Homes. Lakota Community Homes has a building out there. We have an appeal on Lakota Community Homes on the entire property they've got out there. I've learned a lot about Lakota Community Homes. It's a homeowners cooperative. It's not a government entity. It's not a benevolent organization. The homeowners out there can qualify for an owner-occupied classification. The building they got, they're using it for a daycare. I think a daycare rents some space in the building. It just shouldn't be exempt. It has been in the past, and it shouldn't be. So I'd like you to pull that one off, and we'll deal with that one separately. Otherwise, recommend approve the exemption on all of the others.
That'd be my motion.
Moved by Hadcock,
Second.
seconded by Buskerud to approve the full exemption list minus the Lakota Homes. Any discussion? Seeing none, all in favor indicate by saying aye.
Aye.
Aye. Motion carries unanimously.
Okay, so let's deal with Lakota Homes when we get to the end of everything. Let's go to partial exempts, 2018. There's nothing different about these partial exempts. I recommend that you approve the exemption on all of these, except that they're a certain percent exempt instead of 100% exempt. I recommend that you approve them. They've been exempt in the past. I think they should be exempt again. There's a lot of them there, but the Retired Enlisted Association is one of them, and John Martinez is a treasurer for them, and he wanted to address the board about that before you act on all of these.
You need to come up here, John.
Yes, I understand in talking with Mr. Shannon here. My question is, our taxes from 2015 and 2016 for our organization were at approximately $6,000. For 2017, that has changed to $16,000. We were wondering why such an increase. In talking with Shannon, we went over some of the particulars as far as our exemption, and he said that the 2017 taxes cannot be changed. I understand that, but we will go over the exemption status for the 2018s. But that's a heck of an increase. That's threefold over. Question is why?
Thanks.
He explains that it was redone, and that was what he came up with.
Okay.
That's all we have, sir.
Shannon, could you help the board out with this? Give some history on this?
Okay, so all of you know that last year we looked at all of the veterans and fraternal organizations and interviewed every single one of them and found out how their property is used. The law says that it has to be owned by an exempt entity and used for an exempt purpose, but some of these, all of these on this partial exempt list are used for a non-exempt or a non-benevolent use. Most of the veterans fraternal organizations, it's a bar and restaurant, maybe some other things that are non-benevolent uses of the property, so they become a partial exemption. There was no logical basis for that percentage on all of these properties in the past. And I kept getting questions from the different organizations, why is ours at this and theirs is at that, and there was no answer. So I went out and I interviewed every single one of them, and now that percentage is based on how they use that property. I interviewed John there at TRIA. We talked about that. He wants to talk to me when we're done with this meeting. We just had a brief conversation in my office. He said some of the benevolent uses have changed. They have more VA meetings there. We might tweak some of that. So I'm thinking I'm going to come back to you on the 20th and say, I want you to change that. I told him probably not going to change much, but we can at least get better, more accurate information. So we're going to do that after this meeting. Now, we reviewed all of the veterans and the fraternal organizations last year. Now, all of you know that the Legion has appealed their exemption from last year. We are currently at the Supreme Court level on that. They argue that all of the income from the bar and restaurant goes to the Legion's charitable purpose. But the law says it's the use of the property and not the income that's important. If the Legion were to prevail in that case at the Supreme Court level, it will change how we do all of these, because I will say that I think all of these organizations use all of the money they make for their benevolent purpose. There won't be any property that's partially exempt, because 100% of the money is used for a benevolent purpose. I don't think that'll happen because we have a statute that sets up that percentage exemption. I think we're going to win at that Supreme Court level, but we haven't yet. And where we're at is the state's attorney has filed a brief to the Supreme Court. The Legion has 45 days to respond to that, and then there's a 15-day response after that, and the Supreme Court takes it up. So we're waiting to hear on that. Talked to Michelle about this, Michelle and Jay, last week, and they suggest that you go with the recommendation on these this year, and if the Legion prevails in the Supreme Court, we will have to do something else here, and these properties will have the right to preserve their appeal rights, and we will have to change it if it wins at the Supreme Court. It'll be months before we hear, but we will have to do something then.
So when is that happening?
Ms. Hadcock?
Sorry, when is that happening?
Don't know.
How
So
long does it
Michelle
usually
has got her brief to the Supreme Court. The Legion has 45 days to respond. Then there's a 15-day response period. The Supreme Court takes it up. When we get a decision, we don't know, but it'll be months away. It'll be this year, but it's a while away. And at that time then, if we have to, we will have to ask these organizations to appeal. We can't just change it. They will have to file a formal appeal, and then I think we would have to do something.
So if Mr. Martinez is, you're going to look at his, can we continue his then?
I
Till-
suppose.
Till the 20th?
Act on,
Makes more sense than to make a decision on it today and then have him come back.
well, I'm going to come back on Monday with something for you anyways.
That's what I'm saying.
Yeah. Because I'm going to talk to him. So with the exception of that one, because maybe when I calculate the percentage, I add up all of the hours and days that the property is used for a benevolent purpose and all of the hours and days it's used for a non-benevolent purpose, and I calculate that percentage. So he told me the bar is not open on Sundays. I need to adjust that because I counted that day. He said there's more VA meetings in their property this year than there was last year.
Yep.
Okay, so I'll tweak that and I'll come back with a different percentage.
So, are you done, Deb?
Yes.
So, on the 20th, you're going to come back anyhow, but you're looking for a motion to approve this as is, but knowing that it's going to get brought back up on the 20th.
Yeah, or you want to pull it off and act on all of them except that, I don't care.
Yeah, it's up to you.
Okay, that'd be my motion is to approve the partial exempts and then continue Mr. Martinez's for Monday. That's my motion.
There's a motion. Is there a second before I go to?
I'll second.
Motion was made by Hadcock, seconded by Buskerud. Discussion, George Farabee.
Well, we're on the subject, and it's not directly to the motion, but have you run rough numbers on how much, if we're gonna have our assessment, total assessment changed if Supreme Court rules the wrong way?
No, I haven't.
Rough number?
I don't know. The TRIA, the VFW, the Legion, what are all of those $400,000 properties?
The Moose, the Eagles Club, I mean, we're talking dozens, right?
Yep, and if they are 60% taxable right now, that goes off the tax roll. Okay, so we're talking $200,000 or $300,000 for each of those properties. The big one is the Elks Club. They run a golf course on a lot of land out there, and that's a pretty valuable property. And right now, they're only like 3% exempt. So that'd be a lot of value that'd go off the tax roll.
Mr. Chair, I'd like for us to direct Equalization and give us a rough number, and if that's not asking too much in the next couple of weeks
Yeah, I
to
can
see
do
what
that.
impact that might be if the Supreme Court rules the wrong way.
I think Shannon said he can get those numbers and bring them back to us.
Keep in mind that that would impact only the properties that are partially exempt. All those that are 100% exempt are already 100% exempt. It's just those that are partially taxable could go 100% exempt.
I don't understand, but
Now-
it'd be nice for us to know what impact that might have.
We'll calculate that.
Okay.
Now, the Supreme Court could say the percentage exemption is not this, it should be this. But I don't see them doing that. The Legion is arguing for 100% exemption, and I think the legal argument will go one way or the other.
Okay.
Mr. Chair, and the hearing examiner decided not partial, but all the way to 100%, right?
Yes.
So, okay, thank you.
Yeah,
Okay.
and I think that's, if it goes against the county, that'll be the decision from the Supreme Court, most likely. So,
All right, Mr. Chair. Thank you, Shannon. Next, Mr. DeSanto.
Shannon, these percentages are based on hours open, correct? Not based on 24 hours a day, but based
No.
on hours open?
the statute says the property is exempt when it's used exclusively for an exempt purpose. But 20 years ago, maybe, there was an argument that went to the Supreme Court that set up the percentage exemption that we do today. A church camp, and I don't remember what church, but some church camp in the hills here, used the property for a summer camp, church summer camp, but you only do summer camp like 3 weeks out of the year. So in the off season, they would rent the property out to different organizations that were not church related. The issue was not how much they rented it or whether they rented it. It was that it was used for non-church purpose. The Supreme Court says that you add up the number of days that it's used for the summer camp and the number of days that it's used for non-church related purposes, and the winter time is just split at the same percentage.
Any further discussion? Motion on the floor is to approve the partials with the exception of the TRIA to be moved to the 20th. Any further discussion? Seeing none, all in favor indicate by saying aye.
Aye.
All opposed, motion carries unanimously.
Okay, so go to the list for new exempt properties. This is properties that have applied for an exemption this year that haven't been exempt in the past. Not necessarily that they're new organizations. You can see Rapid City Regional Hospital. But Rapid City Regional Hospital has some property that they have applied for an exemption that property wasn't exempt in the past. We just create this list so you can see what new properties are going to be exempt. And I recommend that you grant the exemption on all of these.
Is there any discussion on the new exempts?
Mr. Chair,
Mr. DeSanto?
regional, a nonprofit?
Yes.
They are.
There is all of the statutes that define the exemption require that the property be an exempt entity, and there is a statute for a school, a statute for a hospital, a statute for a benevolent organization, a religious organization. So there's several of these statutes. They all equally say have to be owned by an exempt entity and used for an exempt purpose. And most, if not all, require that the organization be a nonprofit. Not every nonprofit is exempt from property taxes, but there is a statute that says a nonprofit hospital is exempt from taxes.
And not every nonprofit is nonprofit. You get that?
Sure do.
Well, I think we had this discussion last year, too.
I have a question, Mr. Chairman.
Ron Buskard.
Some of these that have been around before, I'll just pick on AA, Lano. Did they buy new property? What happened? Why? And, that's just one. How about some of these churches that have been around forever? Black Hills Workshop, Behavior Management. Are they buying new properties, or why is all of a sudden they're becoming exempt?
Okay, short answer is I don't know, but Deb is telling me she can tell from the parcel number, some of these parcel numbers are new parcels, so there has been a split, and a new parcel number is created.
Okay.
It might have been property that they've always owned, but it's a new parcel, a new legal description, so it shows up on our new list.
Okay.
Or it could be a property that they just acquired. Church of St. Therese, the Little Flower, they bought the lot next door that had a house on it. They took the house off and they're using that as extra parking. So they bought that.
So some of these could be exempt last year, and then they just got split in half, so now we have to include the new one.
When I said the property wasn't exempt in the past, well, okay, if it's a new parcel number,
Yeah.
that land might have been exempt last year, but
I
the
get it.
parcel number's new.
Bighorn Canyon, they bought a new, basically, church out off of Anderson Roads. Okay.
Thank you.
So you're looking for a motion to approve the new exempts.
Yeah, recommend that you approve all of the exemptions on these.
Moved by DeSanto. I didn't catch your second.
Second.
Seconded by Hadcock to approve the new exempts for 2018. Any further discussion? Mr. Farabee.
I've got a question. Net effect on the non-taxable assessment. Could you this is going to reduce the taxable assessment for Pennington County. And some was already, because of moving numbers around, tax exempt, but what's the net difference? In other words, how much are we going to lose in assessed value?
We'll add that up for you and get back with you on that.
Thank you.
Any further discussion? Seeing none, all in favor indicate by saying aye.
Yes.
Aye.
Aye.
Opposed? Motion carries unanimously.
George, you'd realize that it's all your fault. You just made the vote. I didn't do it. You know, that's what I tell people.
What's that got to do with my question?
Good job, Shannon.
I did have somebody that walked up to me at a meeting with the Board of Realtors in town. There were like 120 realtors, and I made a presentation on mass appraisal and how we do what we do. Before the meeting, he walked up and he says, I got a problem with all of the exempt properties. I think there's too many. And some of them I don't think should be exempt. And I hate general statements like that. I told him, tell me which property and I'll go look at it. Okay, give me a property and I will take a serious look at it. But as far as the big picture, we have state statutes that set up what's exempt. And if they meet the requirements in that statute, I have to make a recommendation and you have to approve it if they meet the requirements. So there is some responsibility on this board, but most of it lies with the state legislature that created the statute.
Thanks, Shannon.
Okay, so the last one here, exempt denied. These are properties that the exemption is not denied, but I am making a recommendation to you to deny the exemption, but I want to address why. The first property is Westminster Presbyterian Church. That is not their church property. They have a rural residential lot out off of Nemo Road. It doesn't have a house on it. It's a bare lot. When they filled out their application for exemption, they included an application for this lot. They're not using it for a church purpose. I've talked to them about it, asked them why they got it. They plan on selling it. It doesn't qualify for an exemption, but we got an application for it, so I'm recommending that you deny that exemption on that one. All of the others would otherwise be exempt properties, except for the fact that they didn't get an application to my office by the November 1st deadline. One of them, what do we got? The Boy Scouts. We never got an application for exemption from them until just last week. Because they didn't get the application in by the deadline, I think I have to recommend that you deny them. But I got to tell you that otherwise, they qualify for the exemption. And we got a couple of those organizations here. United Way is one of them. There's a representative from the United Way and Boy Scouts and Boy Scouts. And we called all of these that were on this list and told them there was this meeting to see if they wanted to show up and say something.
Mr. Chair.
Mr. DeSanto.
How many of these, Shannon, are, I guess I would call them repeat offenders? How many just typically don't get their applications in on time, and how many are, this is a first-timer thing?
I don't know. We always have some like this every year. Sometimes it's some church in Quinn where the church secretary died and the new church secretary has no idea what an exempt application is. Okay, we get that kind of story every year. We get some of them, the Girl Scouts. I wonder if there's a disconnect between the local Girl Scouts and the office in Sioux Falls. Some of them, it is an every year thing, but I don't think there's any devious intent to it. I think it's just simple neglect. Some of these organizations think that we're exempt from property taxes, that's it. Well, the law actually requires an application by a deadline and action from this board. It isn't just forever and always kind of a thing.
Mr. Chairman,
Are you done,
I
Mark?
think this is fairly easy. Is there a law that enables us and entitles us to grant them the exemption even though they're late? Can we legally do that?
I'm not a lawyer.
No, but you're the head of our equalization department.
Yeah, there isn't a law that says even though they missed the deadline, you can grant the exemption. You do every year anyways. The law says they have to submit an application by the deadline.
But sometimes there's a law that says, if you don't like what's going on, bring it in front of the county commission and they can equitably do something.
It's an abatement. With the veterans exemption, there's actually a thing in the statute says if you miss the deadline, you can come back and ask for
There's no
an
such
abatement.
thing as that.
There isn't that here, no. I don't, they missed the deadline. They missed the deadline, but I gotta say, I don't know how strong that will be if it goes to court. All I can tell you is the law requires an application by the deadline, they didn't do it. And I bring that to you then.
Ron? Well,
I call it the Nazi defense. I was just following
Yeah.
orders.
I can't, the reason we put these on a list is I am not gonna hide the fact from you that they
And
missed
I
the deadline.
appreciate that, yeah, I
Yep.
appreciate that.
So I have to recommend deny, but then I tell you that otherwise, they qualify.
And I will note on here, if you look at the dates, it's not like they came in January, February with some of the,
With the exception of the one from last
yeah,
week.
yeah, except for that one.
Yeah.
I would move for approval of approving the exemptions on these.
Motion's been made to approve. How do I word that? The denied ones? How would that motion read?
I would just reference the spreadsheet, the exempts denied, just so she knows which ones.
So you're approving to deny them, or
No,
you're
then I'm
approving them?
approving to give them their exemption. I
Except-
would move to approve exempting the denied exemptions.
Would that be minus the Westminster Presbyterian Church, that property that they plan on selling?
Yes,
So that would-
minus the Westminster Presbyterian Church of Rapid City.
Is
And
there,
you should probably have a motion to that specific property after you do all the others, maybe.
okay.
I'll second for discussion.
So the motion's been made to approve the denied sheet minus the Presbyterian.
And you're moving
Westminster.
to approve
Westminster.
exemptions though, right?
Presbyterian.
You're
Okay.
moving to exempt them.
Oh.
Okay.
And
And there's a second by Hadcock. Discussion.
Chairman,
maybe you want to hear from the two entities that are here.
Chairman,
Okay.
if we just approved them, they're just happy, I think, and,
No.
Right. right.
So Ms. Hadcock had a comment. We'll go to Hadcock.
I guess that was my comment, and the other is that it seems like we're gonna end up giving in their, or not exempt or whatever,
Accept their application.
accepting their application, because if we go through all this, I believe it's gonna end up that we're gonna accept them, so, wasting their time and ours without being mean. But it is good that at least I know on the Boy Scouts, they called you like 4 times and stuff, so if you can, please, for the future, acknowledge our staff and then try to get that application is the only thing. Okay, thank you, sir. I appreciate
Chairman.
that.
I would sure encourage this board, because I won't be here next year, thankfully, doing this. It's the worst time of the year to equalization, but I would sure encourage you to keep a list of these people, and once is enough. Next time, I wouldn't do it.
That was kind of my point.
I agree with
Okay.
you.
Okay, so yeah, when you ask how many of them happens every year, I know there's some, I just don't know which, so maybe we try to keep
Not all
better
be
track
on
of
this
that.
list, they might be off this list this year and back on
Yeah.
it again next year.
Oh, yeah.
Okay.
Mr. Farabee.
Got a couple of comments or questions or concerns. Number one, all these organizations except all these organizations were exempt last year.
Yes, but I'm not sure about and I'm pretty sure the Presbyterian Church was not. The others were, I'm almost positive.
And to Commissioner DeSanto's point, how many of them repeat? How many of them were late last year?
He just,
I don't know which ones. I hesitate to pick out those, but there's probably at least a couple of those that were.
And then my second concern, Mr. Chair, is I'd like to have Commissioner Buskerud's question answered by a state's attorney, or at least his opinion. Are we legally on firm ground?
I can pose that question to Jay. You still have days left of Board of Equalization to change your mind.
My substitute motion, Mr. Chair, is that we defer this until we get an opinion from the state's attorney's office.
I'll second that.
I don't have a problem.
I guess, are you, the denials are for the whole day?
My motion was to defer it until, and obviously we have hearings coming up next week or week after, so we can defer until such time as we get state's attorney's opinion.
Yeah.
I'm sure all George is talking about is
The denials?
The denials, yeah.
Just the denials?
Right. Just the
Okay, that's what I was looking for, is for clarification.
I think so.
Isn't that what
speak
our
for
schedule
George,
is, though? Is the denials today? So what he's saying, if I'm right, is that we'd have to deny we just don't have the hearings today and we have them another day.
My motion was to
Okay.
defer.
Yeah,
I don't think you need
Yeah, but they're
to-
all on this.
I don't think you need to defer technically, because you will not adjourn. You will recess because the Board of Equalization still has more days to meet. We plan to take this up on the 20th again with some of these anyways.
Okay, so Chairman, you understand that what's on this paper is on the exemptions denied. So our hearings today are on the exemptions denied. So we would not have a day today, we'd have to defer that as well to another day, am I correct?
no, just these exempts denied is what we're talking about. That's what, George, you're talking about, referring to.
But our.
Yeah,
see,
the
our
rest of
hearings
those,
Are
that's-
on this,
that's what,
that is.
yeah.
So
What you
if we're deferring it, then that means that we're not making. The first time, we just said they're all good, so they didn't have to come in and the day is done. Now we're saying defer it because we want an attorney's opinion and that we need to hear them anyway today, and then we're just gonna tell each one of them we're deferring it?
Well, you will take the issue up again on the 20th. We've got exempt scheduled for then, so regardless, you're going to take the issue up at least with some of these on the 20th.
Yeah.
If Tria wants to come back on the 20th,
Yeah.
he's going to do that.
Yep, one.
So it'd be the TRIA and these ones we've already approved, made motions and approved, the partial exempts, the full exempts,
Yeah.
the new exempts. So it's only this,
Birthright down all the way till 12 o'clock.
yes, we could deal with that Westminster Presbyterian Church after this motion. That was the.
Okay.
Is that what the,
Those of us that are here, the right to get ours heard today, or do we have to come back on the 20th?
so now, please come up and identify yourself and speak, and that's what the motion on the floor is to defer it to the 20th, all the, yours and,
So I'm Mike Lewis. I'm the council commissioner for the Black Hills Area Council. I'm the lead volunteer leader in the council. We do not have a scout executive, so that's why I'm here today. He's gone to a different position. So what I'm hearing you say is that if you deny this list, I have to come back again on the 20th.
yep,
Why can't you hear from us today and approve our exemption today, except from that list, so that we don't have to come back since we're already here?
Chairman,
Miss,
That's my question. There's no reason why
Okay.
we shouldn't be able to do that.
because
Good
they
point.
want
Ms.
to
Lake.
hear from some people want to hear from the attorney to see if.
This
it's
has
safe.
nothing to do, ma'am, with the attorney.
I didn't say
You're
me,
just pulling
sir.
us off the list.
I didn't say me, sir. I'm just saying, we haven't voted yet, but
Right.
I understand where you're coming from, but that's why this is happening right now.
So my request would be that if you deny this or defer it, that you allow those that are here today to talk today, so we don't have to come back.
yes. So please, you've expressed yours. Is there anybody else in the audience that's on this list that would like to speak
Mr. Chair, may I clarify?
Yes,
The-
Shannon.
The board takes actions on the exempt properties today, and then the property owner, if he's unhappy with that decision, the law says that he can come back days later, and I forget how many days it is, at least that many days, and we have scheduled for the 20th. For all of those that are unhappy with the board's decision, they have the right to come back later and make an argument. There are a couple of people showed up today anyways, but the law allows them the right to come back if the decision of this board is something they don't like.
So Shannon, have we in the past, for people that signed up a little bit late, totally denied the whole list as, nobody's saying this is denied today, but you know what I'm saying?
Hasn't happened in the past.
Okay.
So, Chairman,
Ms. Hadcock.
in the past, we've done this. Has the state's attorney come back and said that this is illegal?
I don't know if anybody's ever asked.
But we've done it how many years?
I'm not gonna say just because we've done it in the past, it was right.
I'm just saying, we're, I don't know. I guess I don't agree.
Mr. Chair,
Hold on. You want, Mr. Farabee?
I think the Commissioner Buskerud's question was a good one, and I think we should get an answer, or an opinion. And
And-
that's all I'm asking.
If I may, Mr. Chairman,
Mr.
to
Briscoe.
answer this gentleman, maybe I'm wrong, but the way I'm reading it and the way I believe is, you're gonna get your exemption. As long as the state's attorney says we have the authority to grant it. That's where the state's attorney comes in. If we don't have the authority to do it, we can't do it. And so do you have to come back? Sure, welcome to it. I don't think you have to. My opinion is, if he tells us we can do it, we'll do it. If he says you can't do it, we're not gonna do it. That's simple. But
Mr. DeSanto, would you have a comment?
I was just, I guess, mirroring Ron's comment right there, is that the reason that you might have to come back is because if our state's attorney says we can't do it, well, we're not gonna be able to do it anyway, so there'd be no point in coming back.
But you need to come up here, you can't speak from. The motion is to hear it on the 20th and get feedback from our attorneys to see if there was any legalities saying we can or can't do it.
And that was because the original motion was to approve this list in spite of that. So the question in the motion was not whether you can approve the exemptions that are on the list. The motion is whether you can approve it by changing the intent and the purpose of your list.
This was a substitute motion. The first
Substitute,
motion was
yeah.
never voted on.
Yeah.
So, Chairman,
Ms. Hadcock.
let me ask the opposite. Can we not approve it today, and then if it's wrong, on the 20th, we have to have them come back? That's a lot easier than doing the opposite. You can approve them today, as DeSanto had said, then on the 20th, say, it's not legal, you guys are gonna have to come back for the hearing. Because that's a lot simpler than having them come back again.
Shannon.
I don't think it matters what your decision is today. They have the right to come back at a later time. So you can deny the exemption. They
That's
have
what
the
I'm
right
saying.
to come back.
That's what I'm
and
saying.
And the board can listen to them. You can approve it and still take it up again on the 20th.
Yeah,
I'm
that's,
saying.
yeah, I think.
Save them time from coming
Mr.
back
Farabee.
twice.
I don't know about your other four, but I have no problem with the people that are here talking today. And I think we can remember what they said when we make the decision, yea or nay, on the 20th or whatever day it is. I have no problem with hearing them today, since they're here.
And I called all of the people that were on this list and told them about this, told them they have on the 20th to come back, but this is an open public meeting, so I said the board is taking it up if you wanted to come today.
So let's hear them today. They're here. Let's hear them.
Let's make we have a vote to take.
Yeah. Does anybody else, I'll ask one more time, does anybody else want to speak on this? It'd be good. And I'll repeat, the motion on the floor is pretty much to take this up on the 20th, not take action on it at this point in time.
I guess I'm a little confused, but
So-
I'm just here. I'm from United Way,
Okay.
and we were one day late on ours, and was just told it'd be a good idea to be here to
It's way too hard.
state my case, so, we were one day late, we were in mid-campaign, it's no excuse, but we were one day late, but obviously it would greatly affect our budget for next year, so.
Okay, thank you.
Vote. Call for question.
I need to make a comment because I had.
Oh, go ahead. Sorry.
I believe we were on the right track with the original motion, so I'm not going to support the second one because we can always change it coming back after we hear from our state's attorney. So that's how I feel on this. So at this point in time, we're going to take a vote. All in favor of the substitute motion indicate by saying aye.
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 All opposed?
No.
Aye. Motion carries 3-2 with LaCroix and Hadcock voting no, so we'll be taking this up after we hear from the state's attorney on the 20th.
So I will send Jay an email asking specifically about late or missing application and reference the statutes and see if he gets back to us by the 20th.
Okay, thanks, Shannon.
Mr. Chairman,
Mr.
I would like
Busker.
to add the Westminster Presbyterian Church of Rapid City's property on Ponderosa Ridge Estates to our equalization
Denial.
list.
Second.
To the tax roll?
To the tax roll.
Okay.
That's what I meant.
There's a second.
Yeah, motion made by Busker, seconded by Hadcock. Any discussion? Seeing none, all in favor indicate by saying aye.
Aye.
Opposed? Motion carries unanimously.
Okay, so the only other one is Lakota Homes. We pulled that off the list, and I wanted to explain what that is. Lakota Homes, Lakota Community Homes is a homeowners cooperative north of the interstate, North Rapid. There's 198 homes out there and this one commercial building. Lakota Community Homes has appealed their assessment this year, and on the 20th or something, there's some other date, we will have an argument about the value of those homes. They've appealed to the city council, now it's coming here, and whether the property should be classed as owner occupied. Lakota Community Homes is a homeowners cooperative. Every person every owner that lives in a home owns a share of the cooperative. They pay rent on those homes, and it's government subsidized rent based on their income. I always thought that there ain't no way they could qualify for owner occupied because I thought it was some quasi-government entity or something like that. It's HUD housing, all of that. We had an attorney come in and explain the corporate makeup of Lakota Community Homes. It is a homeowners cooperative. Everybody owns a share of it, and then therefore would qualify for owner occupied, at least on theirs. We haven't had it hasn't been owner occupied for many years. We do have some owner-occupied applications. So we created a spreadsheet of all 198 parcels, and we matched the current occupant of the home with whatever owner-occupied application we have most recently. And a few of those actually submitted an application and would qualify for owner-occupied. So when it comes up to county board, I'm going to recommend that you change the classification to owner-occupied on those. I'm not sure if the attorney is going to argue owner-occupied on all of them. I don't know. Then we're going to argue about the value. Now, we did a reappraisal of the neighborhood up there, not just Lakota Community Homes, but the entire neighborhood, and we changed some values. The City Board of Equalization lowered our assessment. We are bringing that value issue to the county board and requesting that you keep our value at what we had previously, and the attorney will argue against that. Now we've got this commercial building. Well, now, knowing what I know about Lakota Community Homes, you can see the building there. There ain't no way this thing meets the definition of a benevolent organization. They submitted an application and have for several years that say that it should be exempt as a benevolent organization. And the statute says a benevolent organization is any lodge, patriotic organization, memorial association, educational association, cemetery association, or similar. A benevolent organization also includes a congressionally chartered veterans organization. Lakota Community Homes is none of those. They're a homeowners cooperative. On their application, they say that the property is used for entertainment, recreation, instruction, and social opportunities for Lakota Community Home members, children, and young people who, because of financial limitations, would not be able to otherwise enjoy such opportunities. But the property is being used for a daycare. There is a daycare in part of it, and then in part of it, Lakota Community Homes has their board meetings once a month or whenever, however often they meet. Lakota Community Homes is not a benevolent organization. The use of the property is not a benevolent use, sort of a secondary matter because Lakota Community Homes is not a benevolent organization. I recommend that you deny the exemption on this, and I'm not sure if on the 20th, I sort of think so, that their attorney might come and argue this, and I have no idea what they're going to say.
Chairman,
Madam Chair, or
Madam Hadcock. So this is not a community center? Is it just used for a daycare? Is it used for a community center or anything else?
When we went out to look at the property, there's a daycare operating in it. I assume they lease it to the daycare. While they were there, the manager of the property talked to the lady with the daycare and say, can we use this part of the property for our board meeting on this night? And she said, yeah, that's fine. We'll be out of there by that time. That's what we know of the use of the property.
Okay, because I think that's used more as a community center. Am I right, Lloyd?
Yeah.
From what I've heard from other people out there, they've used it for different things, and
I
I
think
don't
the
know how
intention,
that.
when it was built, was to do a lot of stuff as a community
Yes.
center, and maybe not all of it has happened.
Right, and maybe they can prove that it's more of a community center, and I don't know if that, like you said, if that's benevolent or not, but you said
But it doesn't
educational
matter.
purposes and,
It doesn't matter because the owner is not a benevolent organization. You could take one of your properties and say, I'm going to let the community use this property for all of these kinds of things, and that'll be a really good thing, but the law requires the owner to be a benevolent organization as well as the use.
that's true.
And they are not benevolent organization. I could argue that it's not a benevolent use, but I really think that's a secondary issue because I think they do have some use there that's very good for the community. They're not a benevolent
So
organization.
there isn't a government agency that helped build the building or that is involved with that building that would be benevolent?
Well, I think they had some government funding to build it, but the owner is Lakota Community Homes.
Okay.
personally, Shannon, I struggle with this and everything that you said today because with owner occupied, non-owner occupied, renting, I've seen families that lived out there from 25, 30, 40 years in the same house, and so when they say owner occupied, and I know what you're saying with legal, but I'm just saying personally, I'm struggling not only with this, but with homeowner occupied. Just me personally, I'll probably be voting no. I need more information before I can do more research on this than making a decision today. That's just my opinion.
Like what information?
I don't know. I need to sit down
With them.
in a quiet room with you and try to understand and probably maybe go ask some of the board members, organizations up there what
A bit of history on the owner occupied. Several years ago, I questioned the manager of the property about the owner occupied and was told, oh no, doesn't classify as owner occupied. They all rent. The attorney this year made a very good case that the people that live there are owners of the cooperative. And so we've got 198 owners that own a undivided share in the cooperative, but they each live in a house. Okay, that's not so unusual, I I have a problem with renting the house you own and receiving government assistance on your rent. But ignoring that, they are an owner of the property and they live in a house that's not much different than a family corporation, a ranch where there's two houses, father and son, and both houses are owned by the family cooperative, but this is his house and this is his house. As long as I get an application, the law requires an application, we grant that as long as they're separate houses, and it is actually their principal residence, which I think these are their principal residence. I just need an owner-occupied application, and on some of them, we do have that.
Chairman?
Ms. Hadcock?
So a co-op that gets subsidized housing, got funding from the government to build a community center, and now we're going to charge them, take them all to owner occupied? And who gets the money? I mean, the co-op gets the money, and what's the co-op do with the money? Does it fix up the buildings? I mean, is
Yes.
it like Deb owns a co-op and then we're missing a piece or something in there?
The cooperative,
Probably like an HOA.
it is, yep, and the cooperative charges rent to the people that live there. The government subsidizes a large part of that rent, but let's say it's $800 a month rent for a house out there, and the government, to varying degrees, pays $600 a month of that, but the co-op gets $200, and they use that money to maintain those buildings out there.
Okay. Yeah, follow up. So what's your recommendation?
With this property, with the exemption, I gotta recommend deny the exemption. They are not a benevolent organization. They're not a lodge, a patriotic organization, a memorial association. They're not a veterans association. They're not a benevolent organization.
And,
They're like a homeowners association.
and like you said, their attorney plans to be here next week?
Yeah, I think so.
Okay.
Yep.
Mr. Chair.
We do have some homeowners associations that have common land. There's a lot of subdivisions that when they're developed around a really nice property. And everybody that owns a property out there owns an interest in the common land. All of that common land is on the tax roll. Occasionally, we get one of those owners that come to the board and they think that common land should be exempt from taxes. But this is your group. You 50 people got together and bought this land, and I can't go out and use it. And whether you let me or not, it's still yours, and you are not a benevolent organization.
Okay, thanks, Chip. Mr. Farabee?
This list of full exempts, where is West Hills Village on here? Benevolent, charitable, healthcare? I can't, I probably looked in the wrong place, but I can't see them.
What's that got to do with what we're talking
Yeah,
about?
we're talking about the Dakota Homes.
West Hills Village. Well, but where I'm going with this is, you talk about daycare for the kids, isn't West Hills Village kind of adult, or daycare for the adults?
There's no statute that grants an exemption for daycares. West Hills Village is a congregate living facility. There's a statute that specifically exempts congregate living facilities, the assisted living, the rest home.
Which category?
I think we've got it. Deb says last page, congregate housing.
Oh,
Rapid City Good Samaritan Housing, that is, I
that West Hills Village? The very last one?
think that's,
Yep.
that's a different one. That's not West Hills.
Good Samaritan. So what's the co-op called,
Wait.
Shannon?
Lakota Community Homes. Lakota Community Homes LLC. West Hills Village, isn't it like Presbyterian or something?
Oh, then it's under healthcare on page 6,
It's under healthcare?
under healthcare. If it's the Presbyterian, yeah, West
What,
Hills.
Presbyterian, okay.
Yeah,
It's
it's
not West Hills Village, it's something Presbyterian. And, okay, we've got it under healthcare, it probably should be under congregate living.
Oh, okay, well, like I say, you mentioned daycare, and isn't that kind of like adult daycare?
There's no statute that grants an exemption from daycare. We'd have a lot of properties exempt if daycares were exempt.
All right.
My girlfriend would be happy with you. She runs a daycare out of her house.
Okay,
Oh,
okay, folks.
all right.
Does anybody have a motion? Recommendation, could you repeat your recommendation again?
Deny the exemption for Lakota Community Homes.
That's my motion.
Second.
Moved by Buschrood, seconded by DeSanto. Further discussion?
Chairman,
Adcock?
I'll be saying no, because I want to look into it a little bit further like you do, Lloyd, if I could, so, not because I'm in disagreement with Shannon, just want to see, more information.
So motion on the floor is with the recommendation to deny. All in favor?
Whoa,
You got it,
yeah.
Mr. Farabee.
No, they're gonna be here on the 20th?
I think so. I talked to the attorney. He said he couldn't be here today, but he wants to know when that next day is. I already told him it was the 20th. So I sort of think so.
I have a substitute.
So why are we voting today then, if he's gonna be here?
He has the right to come back on that day.
I have a
Just
substitute.
let him finish his follow-up.
Well, I guess I would like to hear him, and if he misses the 20th, well, then he's missed his chance, but I guess before I vote, I'd like to hear what they have to say.
I have a substitute
Ms. Hadcock.
to continue this till the 20th.
There's been a substitute motion to continue to the 20th,
Second.
seconded by Farabee. Any discussion on the continues to the 20th? Seeing none, all in favor of the substitute motion, indicate by saying aye.
Aye.
Aye. Opposed?
Aye.
Motion passes with 3 ayes and 2 noes, no from DeSanto and Buschrood.
That's all we've got for today. I wanted to give you an idea of what we've got coming up. We are scheduled 18th, 19th, and 20th. The 18th is all regular appeals, right? And Lakota Community Homes is one of those, but that will be the owner occupied and the value issue, okay? But the 18th is just regular, ordinary assessment appeals. The 20th, we have something unusual. Last year, the Wall Board of Equalization took a bunch of appeals for properties in Wall and just lowered them down to a certain percentage of what it was from the year previous. It was a bunch of them. We ignored it, and this year put on most of them, put the value back to what we thought it should be. This year, the city called, we think, everybody in Wall and told them to come in and fill out an appeal form. And they took 140 properties and lowered the value back down. Okay, well, we can't ignore that. Significantly, like half what they're worth. So we sent our entire appraisal staff to Wall over several days, and they knocked on 140 doors and met with almost all of them. And if the property owner wasn't home, they left a card on the door, and we even called then those people later. And we looked at all of those properties. We have, most of those, a recommendation to the county board. Our office has appealed all of those properties to the county board. Most of them, we have a recommendation for you to change the value. Most of them, probably not all the way down to what the town board did, but what the town board did didn't have any basis in market value. We actually looked at the properties. I've learned something about Wall. There's a lot of basements there that are cracked and coming in, seriously. And I didn't think Wall had a problem. I thought water caused that, and I didn't know Wall had a water problem other than no water. But there are a lot of houses that have some serious issues. And our appraisers accounted for that, as well as other things. Worn out condition, stuff like that, quality of construction. We have a recommendation to you Several of them, we have a recommendation to the board to lower the value down to a number that was less than what the town did. But again, the town didn't have any logic behind their number. Most of those property owners are happy with us. We had really surprisingly good reception from almost all of the property owners. We won't see very many, but the 19th is scheduled for wall appeals. And we are guessing that we have between 10 and 20 property owners coming in the morning and then 10 or 20 coming in the afternoon that want to argue further. We don't think all of those will show up. I think it'll be less than 10 in the morning and less than 10 in the afternoon. So the 19th could be a short day, although we'll have to come back in the afternoon, because we told this group of people in the morning and this group of people in the afternoon. We might start at 1 and be done by 2, but that's what we have to do on the 19th. The 20th is regular appeals again. It'll probably be a short day. And we just told all of these people with the exemptions that your day to come back again is the 20th. And then we will be done on the 20th. We maybe be done by noon, depends on how long the board wants to go. I should say something about park models. We are currently in court again over park models. There are 5 park models that have appealed to circuit court. We won the hearing at the Office of Hearing Examiners. They have appealed to circuit court. Well, actually, 2 of them went to Office of Hearing Examiners. We won those 2. 5 of them went straight to circuit court. And we are in circuit court over that. Jay has created a list of stipulated facts where this is the facts of these properties. It's a park model built this year, it's this size, it's in this campground, and hopefully we can create a set of facts where their attorney will agree on those facts, and then it'll just be a legal argument about whether those properties are taxable or not, and we don't actually have to argue about the facts. Okay, we're working on that right now. It's scheduled to go to court in May. Again, the same thing, most of those property owners with the park models have appealed. There's 5 of them. I think we only got three appeals this year. And the campground owner wants to call in. So we'll hear that. Same thing as the veterans organization suggests that we keep it the same. If we find out something later on about if park models, the court rules they're taxable, then they've already got an appeal in court. We will have to do something different with those.
Okay.
I expect to win it. I think we've already been to the Supreme Court over park models, and they're no different. The property owners argue that they're different, but I don't think so. So I think we will prevail, and currently scheduled for May.
Mr. Chair.
Mr. DeSanto.
I'd just like to thank you, Shannon, for taking the extra time and effort to address those wall citizens' concerns. I got several calls, and I think they're happy with what you did, and I do appreciate that.
Thank you. It surprised me of the reception we got. I think maybe there's just a few individuals in Wall that are truly upset. I had one property owner, he says he's in his 60s, and he says, I have always been told, don't let him in, don't let him in. He said, when the town called me and said I needed to appeal, I never thought maybe somebody ought to look at my house. He actually had the basement wall coming in. It was coming in. Well, yeah, we like to see that kind of stuff. Standing on the sidewalk outside, we don't know that.
Right.
He said he walked our appraiser around the house, and he said, you can see cracks on the outside, he said, but you really don't see it till you get inside the basement. Yeah, and I was joking with him, and I said, yeah, it's amazing how accurate we can be when we go look at something. We did with Wall. There's going to be a few people that are unhappy, but it will be issues that you face with Board of Equalization all the time. Is the house worth that or not? Otherwise, all of the others, at least there's some of them we haven't been able to contact people, but we've tried. We left a card on the door and we called. We've done what we could. And that's what we do with anybody that appeals. 140 of them was a little bit overwhelming, but we did get through them.
Great.
So, since Mark's here and Shannon's here, what brought that forward that the city would have everybody come in and do that?
Just a lot of people got their assessments and went, holy smokes, our assessments went up by 40% and the real estate values in Wall are not,
Okay.
doing that. They're not, you know.
I should say something about the real estate values in Wall, because we get this question a lot. We do not value a house in Wall the same value we value a house in Rapid. Wall is its own market area, and we value houses in Wall based on what's selling in Wall. A house in Rapid is, this exact same house in Rapid is worth more than if we move it to Wall. That's the way it is. But some people, they question that for good reason. No, we don't use sales of houses in Rapid to value houses in Wall. It's a different market.
Okay. Okay, Mr. Farabee.
I've got a question about park models. Didn't we suggest to the legislature, memory might be faulty, but
Yeah.
didn't we recommend something to the legislature and what happened? Anything?
None.
Nothing.
Yep, nothing. I talked to legislators. I talked to Meade County. Meade County's got a similar argument going on up there. I didn't get anything this year. I go back to last year. I had one legislator that told me there's policy and there's politics. And what you want is policy. And I'm going to do politics. And he said, I supported something the previous year that had to do with taxes. He said, I want nothing to do with anything that might be related to taxes this year. And I mean, he was nice. He's a nice guy. And he was very nice to me, but just flat refused to, don't want to talk about it.
Wow, what a cop-out.
Yeah,
Wow.
yep. Now, there are some legislators that think we don't need to do anything. Our law is good enough. The Supreme Court ruled the law is good enough, so we face some of that too.
Well, Mr. Chair, if I might, obviously, some of us totally disagree with Rushmore Shadows being the same as what's his name, campground out there.
And that has to be the argument in this case, because we've already been to the Supreme Court over the issue of park models and taxable. The only way you could argue differently is if they're different.
Well, Rushmore Shadows is different.
All right. So it looks like we're at the point where we just recess, right?
Yeah,
Yeah, we don't adjourn.
yeah, because the board is still,
Need a motion to recess till the 18th, right?
So moved.
Second?
Moved by Hadcock, seconded by DeSanto. Discussion. Seeing none, all in favor indicate by saying aye.
Aye.
Aye. We're in recess.